Hello.
Hello, can you tell me your name, please?
Harry Ingleson.
Oh, Mr. Ingleson, okay.
Yes, Your Honor.
All right, just 1 minute here. I'm getting Mr. Carey connected. And then we have one other person joining us on the phone with the last 4 digits are 7264. Can you tell me your name, please?
I'm Marie Mullen.
That's Mullins. Okay, great, thank you. Okay, and Mr. Carey is now connected, so we'll go on the record. This is Mullen versus Brzezinski, case number 2118497. The record should reflect that Mr. Ingleson is present today by phone on behalf of plaintiffs. Mr. Carey is present by Zoom video on behalf of defendants. This was set as a control date back in June by the court. Mr. Ingleson, on behalf of the plaintiffs, where are we at?
Yes, Your Honor. Mrs. Mullen's husband works for General Motors. They had a time frame in mid-July to the 1st of August, I think it was, where they could both be there, and we had the surveyor come during that time, and I was able to go also. And where we are is we have an agreement, obviously a settlement agreement. What we do have, however, is a disagreement as to whether or not the survey accurately describes the eastern portion of the property that is being transferred pursuant to settlement agreement. In other words, the survey versus the on the ground, what actually occurs, rather than a rectangle. It's, we believe, evident that it's more like a parallelogram, if you will, or an odd shape. And so, rather than try to explain all that to the court, Mr. Carey and I have spoken earlier today, and my suggestion, of course, the court gets to decide what is, I don't know if it's better for you, Your Honor, to simply say, hey, here's your hearing date, fix it by then, or come in and convince me one way or the other so that we can get this over with. And that's certainly fine with us. And I'm not trying to have a hearing date. We're trying to resolve this, but we haven't thus far survived or succeeded 100%. So the only other alternative to that, I suppose, is whatever you might do in terms of status dates. But we realize we've had a settlement in place in writing, but not consummated it completely yet. It's been there for almost, I guess, over 2 years. We want to get it done probably as much as you do. So that's my status update, Your Honor.
Thank you, Mr. Carey.
As Mr. Ingleson indicated to the court, he and I did have an opportunity to speak about a half hour ago. I was hoping that I could better understand what the plaintiff's disagreement with the survey was. Survey, this is a settlement agreement reached through mediation 2 years ago. The survey was completed in November of 2022. The survey appears to accurately reflect the agreement of the written agreement of the parties reached at mediation. And I think that Mr. Ingleson agrees with me that the survey, as it was completed in November of 2022, tracks 100% with the survey. Apparently, the plaintiff says that on the ground the settlement agreement is not being effectuated, notwithstanding that the survey does effectuate the settlement agreement and the legal descriptions and the deeds that my clients have signed and long ago tendered to the court reflects the legal description created by the survey. It's a long way of saying I'm at a complete loss. My professional responsibilities to my client are being questioned by my client, honestly, and understandably. And I don't know what the best course forward is. Again, for many months now, my clients have completed all of their tasks relative to the settlement agreement. But the surveyor, the same surveyor that did the November 2022 survey, is the surveyor that came out in July of this year to explain why his survey was accurate to the plaintiff and apparently another family member. Since July, there hasn't been another survey. There hasn't been a corrected survey. There hasn't been any communication by the surveyor that says the one I did in November of 2022 needs to be changed, and here's how. Because I don't think it can be, because I think it's 100% accurate, and I suspect the surveyor does too. In kind of thinking this thing through, maybe I should be the one being criticized for not having filed a motion to enforce the terms of the settlement agreement. Maybe we should have had that done a long time ago. I think that's procedurally probably the only thing that makes sense. And, you know, again, I have to say, and this is not a threat. This is not a threat. I'm not mad at anybody. I'm more disappointed in myself than anything else. But if our motion to enforce the settlement agreement is successful and there's not a problem with the survey in terms of its consistency with the settlement agreement, Judge, I'm going to have to push very, very hard for costs.
Okay, well, here's where I'm at with things. We keep having these status conference hearings where you guys tell me basically the same thing that you told me here today. At our last hearing and looking at the status conference order from the hearing back in June, the court did set a motion cutoff in August for the parties to file some motions if they couldn't resolve. So from my perspective, and with an appreciation for both of you and understanding you're trying to get this resolved outside of having to come into court and cost your clients more time and money. But, you know, I tried to set a cutoff date here to push this to a head if there wasn't an agreement, and neither side filed a motion. I think typically it would be the plaintiff's responsibility to prosecute their claims. However, because there's a mediation agreement here, I think either side could and probably should file a motion to enforce that mediation agreement according to the terms that your respective sides believe are appropriate based on the surveys and the facts. Nobody's done that. So here's what I'm going to do to kind of force this at this point is I'm gonna give the parties 60 days to file a motion to enforce the mediation agreement and get it set for hearing. If neither party does that within the 60-day period, the court's just going to dismiss the case for lack of progress, and then you guys can decide whether you want to go back to the beginning or not. But I'm not going to. There's some feedback coming from somewhere here. I don't know who that is, but there's a lot of background noise. Anyway.
Oh, go ahead, Judge.
Anyway, I'm not going to just keep setting this for hearing and pushing it out and pushing it out. So either one side or the other is going to file a motion and get it set within the next 60 days, or the court's just going to dismiss the case.
Would I be able to get a date from the court now? Because I'm going to dictate the settlement motion right in the next 10 minutes.
I can't do that here on the record. That you'll need to call Jennifer and get a date from her.
That's what I would have said if I were you too, Judge.
Mr. Engelson, I'm trying to unmute you there. I think it was your phone, because when I muted you, all that noise went away. Mr. Eagleson is still connected, he's not unmuting. Either way, I don't think I need to hear anything else from council, though. I think that'll settle it. I'm gonna put that into an order. I'll get that out to the parties. And then we'll either have a hearing or the court will dismiss. So thank you. Both council are free to disconnect at this time.
Thank you, Judge, and sorry for the inefficiency here.
That's okay. Good afternoon, counsel. Can you tell me which case you're signing in on, please?
Good afternoon, Your Honor. This is Indra Pandiraj. I'm signing in for the case number 2419708CH on behalf of Mortgage Electronic Registration Systems, Inc.
Okay, very good. I'm just going to put you back in the waiting room for just a minute. I have one other matter to take up before that.
Thank you, Your Honor.
Thank you. Okay, it looks like we have counsel connected for our 2 o'clock. This is Tresha Smith versus Thomas Bauer, case number 2319444. The record should reflect that both Ms. Bailey Quick and Mr. Tompkins are present today by Zoom video. This was set for a status conference, and Ms. Bailey Quick, on behalf of plaintiff, can you update the court on where things are at?
Yes, we filed the conservatorship action. The hearing that the soonest that we can get in front of Judge Cooper is October 15th at 10 a.m. And speaking with Ms. Parker, she, because a lawyer guardian ad litem has to be appointed, she allows a minimum of 30 days. She indicated that Mr. Brown will be appointed, and we could have gotten an October 1st date. However, I'm in a bench trial all day that day. So the next available date is October 15th.
Okay. Mr. Tompkins, anything that you wanted to add to that?
No, Your Honor. Ms. Bailey Quick did send us the pleadings. We have those. And, you know, we'll certainly make ourselves available for the hearing on the October 15th. We did submit to Ms. Bailey Quick for her consideration and of her client a proposed release, and I'm sure that we can work out the terms of that offline, but I wanted to point that out. So,
Okay. Do you want me to set a next date, or Ms. Bailey Quick, do you want to set it for a hearing following the October date, probate?
I would say any date right after that October 15th date, because that should be the one and only hearing that's necessary.
Okay, I just want to be, I don't want to keep forcing the two of you to appear when we, you know. So if I set this for November, or do you want me to wait till December to set it for final hearing?
I would think November would be fine.
I think we can make a date work, Your Honor.
Okay.
November.
All right, so the court will set this for a final status conference in November, and Ms. Bailey Quick, if you could just, you know, file a motion for the court to approve the settlement and set it for that status conference date.
Yep, I can.
Okay.
I can. Yes, I can do that.
All right, anything else I can address for either of you while we're on the record today?
Nothing here, Your Honor. Thank you.
No, Your Honor. I guess if I could just clarify, so you want me to just submit a proposed approval of settlement? I guess I typically do that in the probate court, and so if I look a little perplexed or confused, I guess I'm just looking for some clarification.
All right, normally, excuse me, in civil cases where there's settlements involving minors, then we do have a final hearing to close out the circuit court case. So that's all I'm looking for.
Okay.
Okay, thank you. That's all for today. Both sides are free to disconnect at this time.
Thank you.
Thank you, Judge. Good seeing you.
You too. All right, I think we've got all counsel connected, so we'll go on the record. This is case number 2419708-CH, Kent Family Farm versus Benjamin Vaughn et al. And I could just have counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Judge Paul Slough on behalf of Kent Family Farm.
Judge Jeff Shimovitz on behalf of Benjamin Vaughn.
And good afternoon, Judge Drew Norton on behalf of the Rosemary Kuratalo Trust and Michael Jonas.
Good afternoon, Your Honor. This is Indra Pandiraj, P84364, on behalf of Mortgage Electronic Registration Systems, Inc.
Okay, thank you. So we're on the record here today for purposes of a scheduling conference. I did have a chance to review just the complaint. Generally, I see that the parties did enter into stipulated order, kind of just maintaining the status quo, I guess, during the pendency. I understand this is a boundary property dispute. Mr. Slough, on behalf of the plaintiff, do you want to take a shot at some early mediation here before we set a lot of dates or set some motion cutoff dates? What are your thoughts? And then I'll get input from the defendants as well.
I would not have an issue with that. I think that may be very constructive in this case. The parties already, before the lawsuit was filed, engaged in some discussions about how they might be able to resolve it, and having the attorneys present and a mediator to help kind of facilitate those discussions may be fruitful. So again, I think an early mediation would make a lot of sense. The facts are really not in dispute. I mean, I don't think there's a lot of disputed facts here.
Okay, Mr. Shimovitz?
I think that early mediation may be very constructive.
Okay, Mr. Norton?
Absolutely agree, 100%.
Okay, and Ms. Prayardashian?
I agree as well, Your Honor, with all my brother's counsel in terms of mediation would be a constructive place to resolve this case.
Okay, so here's what I would kind of propose then is just having a pretrial order that indicates discoveries to remain open for the time being to the extent that any parties want to engage in some discovery. Set a mediation cutoff of 90 days. And with parties to, at least at the outset, to attempt to agree on a mediator. If you can't, then the court will provide a mechanism for a mediator to be selected. And then set this for a status conference kind of at that 90-day mark to get everybody together again, see, obviously if the case is able to be resolved through mediation, then we can go down that route. And if not, then we can see where things are at. Mr. Slough, do you have any objection to that plan going forward?
None at all.
Mr. Shimovitz?
No, sir.
No objection.
No objection for me as well, Your Honor. Thank you.
Okay, great. So I will put that into an order. I'll get that out to all the parties. The court will also send out a notice of the date and time for that next status conference, which will be by Zoom, just as we're doing today. And that's all I have for today. Thank you, counsel. You're all free to disconnect at this time.
Thank you
Thank you,
very much,
Judge.
Your Honor. Thanks,
Have a good day.
everybody. Thank you.
All right, Ms. Walsh, can you tell me what case you're signing in on, please?
Jones.
Okay, 1 second.
Hi there, Your
All right,
Honor. Can you hear me? Oh, sorry.
I can't. Nope, you're good. Thank you. Are you Mr. Bentley?
Yes.
Okay. All right, we're on the record in Ryan Bentley versus Riley Gauthier Parrott. This is case number 2419654. And this is set today for entry of a default judgment of divorce. And Mr. Bentley, is that how you wanted to proceed today?
Yes, sir.
All right, this hearing was set for 3:15. It's now 3:18. I don't see Ms. Gauthier Parrott attempting to join in the hearing today. So we'll proceed. Mr. Bentley, I'm going to place you under oath, and then I've got some questions that I need to ask you. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if I could have you raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Bentley, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that your marriage could be preserved. Was that true when you signed that complaint?
Yes, sir.
Does that remain true today?
Yes.
Were there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
To your knowledge, is Ms. Gauthier Parrott currently pregnant?
No.
Under this judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever, that you would not be able to come back later and ask the court for that?
Yes.
The judgment of divorce indicates that you've already divided up all the property between the two of you. There are no debts to be divided and you would each be responsible for paying any debts that are in your own name. Is that correct?
Yes.
It also indicates that you don't own any real estate or real property together. Is that correct?
That is correct.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Mr. Bentley. The court finds that Ms. Gauthier Parrott was properly served with the summons and complaint, that she failed to answer, otherwise defend, that she was properly defaulted back on July 30th. She was provided with notice of the date and time of today's hearing, and as I indicated, has not appeared. So the court will grant the divorce. I signed the judgment. That'll be available here for you, Mr. Bentley, if you want a copy of that for your records. Do you have any questions for me at all?
I don't think so.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you for your time. Appreciate it.
Thank you.
Bye.
Okay, looks like we have all council connected. Just 1 minute here. Okay, we'll go on the record in Peyton Jones versus Munson Otsego. This is case number 2319251. And starting with plaintiffs, if I could have all attorneys put your appearances on, please.
Rebecca Walsh appearing on behalf of the baby Peyton Jones and her parents.
Good morning, Your Honor. Jennifer Sikorsky on behalf of the plaintiffs.
May it please the court, Ralph Valatutti appearing on behalf of doctors Murphy, Minor, Kylie, and Jonette.
Good afternoon, Your Honor. Gretchen Olson appearing on behalf of the Otsego Munson defendants.
Mr. Quant, you're muted.
My apologies to everyone. Joseph Quan on behalf of Acorn Health of Michigan, LLC, and Helena Broden.
All right, thank you. We do have one other person connected here under the name of Jim. Don't believe that's an attorney. I'm not sure if it's a party. Counsel, to any of you, I know that's not a lot of information, but that's all I see on my screen.
I don't know who that is, Your Honor.
Okay.
I can't help you, Judge. I don't have knowledge of Jim.
Me either.
Nor me, Your Honor.
All right, thank you. I'm going to remove that person then. It's hearing. Okay, we're on the record today. We do have a motion up set for hearing today regarding some discovery. And that motion is set for hearing as well as a status conference. I did have a chance to review the motion itself along with the responses and the replies. And I guess, just from the outset, I mean, frankly, I'm a little bit confused about exactly where we stand today, because it seemed like from some of at least one of the responses that probably from Mr. Quant that his individual has been made available for deposition. So I don't know that that's an issue, but I guess Mr. Valatutti, it's your motion. Can you tell me what you're asking the court to do specifically today? Have there been developments that have changed what happened or where you're at since you filed the motion?
Yes, Your Honor. I'd just like you to enforce the law. There's been a waiver of any physician-patient privilege. I've had to subpoena Helen Broden for deposition to find out what she has to say. By rights and by the law as set forth in the D'Amico case, I hope Your Honor has read that case because it controls our situation completely. D'Amico versus Roe, 438, Michigan, 347. That case requires that a plaintiff assert the privilege at the time that the authorizations for medical records are sent out under 2.310. They never asserted any privileges regarding Acorn Health, but when it came time for us to investigate the healthcare providers who were providing treatment and care to the plaintiff at Acorn Health, which wherein plaintiff has listed at least 4 or 5 witnesses in their witness list. We had resistance from plaintiff's counsel indicating, well, you didn't send a subpoena out. Well, we didn't even want to take the deposition of Helen Broden. We wanted to talk to her, in which case, which D'Amico says we can. And instead, I was very happy to at least get the deposition of Helen Broden, but In a recent deposition, another name was mentioned, Rachel Adams, and I want the rights that any defendant has to talk to the healthcare providers who have provided treatment and care to Peyton. And the plaintiff has taken a unique position, and that is that I have to, in this case, for some reason that is unknown to me, schedule or subpoena each witness that I want to take the deposition of. Well, that would be true if I wanted to take their deposition. But in truth and in fact, I want to talk to them to find out if they have anything relevant to say about the case, rather than go the more expensive route. Plaintiffs have executed a waiver of sorts with regard to the deposition of Helen Broden. And to your question, Your Honor, we do have the deposition of Helen Broden scheduled, and it is coming up pretty soon. It hasn't occurred yet. And the plaintiffs have executed an authorization for the taking of Helen Broden's deposition only. Well, I submit to the court that under the D'Amico case, that's a legal curiosity. You can't authorize waive the privilege as to one person that is listed in your witness list from a healthcare institution. That waiver has already occurred, and if I may read to the court from the D'Amico case, pages 355 and 356. The rules in Michigan allow the assertion of the physician-patient privilege at various stages in the proceeding. The court rules do permit, however, an implied waiver when the patient fails to timely assert the privilege. MCR 2.314, parent B, parent 1, requires that the party assert the privilege in the party's written response under MCR 2.310. That rule having to do with the request for the production of medical information, which long ago occurred when we received thousands of pages from Acorn Health. And again, reading in the case, and MCR 2.302B1B requires the assertion of the privilege at deposition. The penalty for not timely asserting the privilege under these court rules is to lose the privilege for the purposes of that action. The rule obviously recognizes, and then it, in a footnote, cites to MCR 2.314, 2.302B, as I read, and then goes on and says on page 356, it is patently unfair for a party to assert privilege during pretrial proceedings, frustrate rightful discovery by the other party, and then voluntarily waive the privilege at trial, thereby catching the opposing party unprepared, surprised, and at extreme disadvantage. Thus, the rule requires that the party choose between the existing privilege and the desired testimony. The party may not have both. The rule is rational in its design because the fundamental concept behind the rule is that one should not be forced to divulge certain information, certain communications. The essence of the privilege is the lack of disclosure, not the time of this disclosure. In this case, as in our case, in D'Amico, still reading, in this case, after the defendant sought the information under MCR 2.310, which we did long ago, D'Amico signed authorization forms permitting the release of the medical information. The privilege was not asserted in the plain language of MCR 314, parent B, parent 1, declares that the privilege is not asserted in a written response to a request to produce, is waived for the purpose of that action. See also Schuler versus United States from the case. The case concluded as that interview of plaintiffs' physicians, medical providers, after the waiver of the physician-patient privilege is allowed. So what I have done is I am going to take Helen Broden's deposition, but I also want to talk to the other persons listed in the plaintiff's witness list from Acorn Health to find out whether or not I want to take their deposition. And if I do, I will then comply with 2.305. And if I don't, I won't.
So a question, I mean, isn't this, I feel like this is, you're asking for the kind of contact that you would have pursuant to either a negotiated, often negotiated qualified protective order, or one that's ordered by the court to allow you to speak. I mean, is that what we're talking about here? Is that what?
Yeah.
Okay.
Well, I don't understand the court's question. What I'm asking for is the right to speak and interview that is allowed under D'Amico versus Roe. Nothing more, nothing less. But D'Amico.
All right, my question was because typically, I'll sign stipulated qualified protective orders that allow defense counsel to speak to various healthcare providers and so forth to determine whether or not, they're informal discussions to determine whether or not they want to proceed with discovery. Sometimes the parties can't agree on that, and there's a motion from the defendants for the court to issue a qualified protective order to allow them to do that.
Well, I think we entered.
And I'm just trying to understand if that's different from what you're asking for here, or that's what you're asking for here.
Well, I believe we've entered into a qualified protective order. For some reason, the plaintiffs have objected because they considered mental health care providers different from, maybe they don't consider mental health care providers different from healthcare providers. The Acorn Group is a mental health care provider paid for by Community Mental Health. But the rules do not distinguish between mental health care providers and healthcare providers. Mr. Quant was citing to section 330-1750, but that section, like all other sections, which applies specifically to therapists, that also has the same waiver provision in paragraph A. I believe a qualified protective order was entered into in this case, which allows me to interview those people.
Okay, all right.
But when I went to set up appointments with Mr. Quant, he said, well, I don't think we have a waiver of the privilege. Well, then I said, well, not me, but Michael Palucci, who was helping me on the case, sent over everything we had, and he wanted a specific waiver. So we sent that specific waiver to the plaintiff, trying to get it done as quickly as we could. This process all started in May, by the way. And then the plaintiff objected and said, well, you have to file a subpoena, which I think was where we got off track.
Okay.
That's in fact something we didn't have to do. And I may have not needed to take Helen Broden's deposition. I'm happy to be able to take her deposition as it's scheduled now. Maybe she can answer all of my questions. But that's where we are.
All right, and I appreciate that. That clarifies it for me, because between the motion and all the replies and responses, it was a little lost on me exactly where the rub was here, but I think I understand now. So thank you for that clarification. Moving to the plaintiff's side of this, either Ms. Walsh or Ms. Sikorsky, I'll ask one of you to address plaintiff's position throughout the time we're on the record here today. Either one, whoever wants.
I apologize. I didn't mean to interrupt you, Honor.
That's okay. Just as long as it's only one of you, I don't care which one wants to do it.
Thank you, Your Honor. It'll be me. And I want to point out, first of all, this very same motion was brought before this court about 2 months ago. And the court, after denying the defendant's motion, ordered the defendants to file an order. I guess it probably is my mistake, Your Honor, that I didn't file one when they did not, but they never entered an order, or we wouldn't even be here today, because this is the same request for the same information. I think that Mr. Valetuti's error comes in even if you have even if you get an ex parte qualified protective order entered, it doesn't force somebody to talk to you. And all you can do is ask. They don't have to sit down and talk to you. And my understanding is, of course, I came into this late in the game. I got a request from Mr. Valetuti's office. I didn't know they had talked to anybody at Acorn. They presented me with an authorization that had been modified from the one Mr. Quant gave to him to include additional information that I said, I'm not inclined to sign all this. Send me the communication from Acorn so I can see what they asked of you. And after they did, I said, well, you know, if you want to talk to Acorn, if we want to talk to the attorney for Acorn, at the time, I don't even think I knew it was Mr. Quant, that might be something different, but I'm not signing the authorization that you're asking for, which basically was giving them permission to do things that I don't believe they're entitled to do. So we came before you and we said, Judge, if they want to take somebody's deposition and we all can't agree on whatever authorization Mr. Valetuti wanted, then they should subpoena the witness. So they did. Mr. Quant then called me, or I called him. He sent me the authorization they wanted signed for that deposition. I had that authorization signed for that deposition, and what the court had, and so that deposition's going. But the order that this court said was, if there's not an agreement or they're not, you know, you can't talk to them, then you need to follow the rules and subpoena them for a deposition. The Acorn can say, I want this or that, or I want the plaintiff's permission to have this meeting, or I want you to notice a subpoena. I mean, that's well within their rights. They don't have to jump when Mr. Valetuti says jump. And that's what we've done in this case. And this motion should be denied just like the first one was.
All right, thank you, Mr. Kwan.
Thank you, Your Honor. I'm going to be the easiest participant in the hearing today, which isn't always my shtick, as Ms. Olson would probably attest. You know, we have no horse in this race. We're happy to cooperate with any party, provide, you know, information. My concern is that we're going to quickly get into areas of privilege with respect to the interviews that Mr. Valetuti wants to perform. I have no problem with these folks being available for interview, but if we're going to get into areas related to discretion of treatment and things of that nature, well, then we're getting into areas that I think privilege is clearly going to apply to, and I'm uncomfortable having my clients basically testify as to potentially privileged issues, or even offer information in an interview that could be potentially privileged, subjecting them potentially to professional discipline or potential, you know, claims in litigation related to the breach of that privilege. The privilege belongs to Ms. Walsh and Ms. Sikorsky's client. They've been great to work with. Mr. Valetuti's been great to work with. We have no interest in being difficult to get along with. We just want somebody to either A, sign a waiver to let these people speak, or B, have the court order us to provide this information, and we'll comply. You know, so we really don't have a horse in the race, so to speak, Your Honor. We're happy to comply with whatever the parties can agree to, or that the court wants to direct us to perform. So, thank you.
All right, thank you. Ms. Olson, anything that you wanted to add to this?
I don't think so, Your Honor. I think it's pretty clear now that Mr. Quant is just asking for an order of the court that the defendants are entitled to. So it seems to me that that's a simple answer.
All right, thank you. Mr. Valetuti, it's your motion. Anything that you wanted to say in response?
No, I think I've covered it all, Your Honor.
Okay. All right. I think for clarification purposes, and because I am now 15 minutes behind my next hearing, the court's going to issue a written order. I think that might help with the parties going forward, understanding how they're to deal with this problem. So the court's going to issue a written opinion. I'll get that out forthwith. It won't take long. And then I'll also address further status conference issues in that order in terms of how we'll proceed with scheduling going forward. I appreciate the arguments of counsel here on the record today, and all parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Ms. Bailey Quick, I've got the other party here connecting, so just gonna be a second.
Okay, sounds good.
Ms. Allred, I'm gonna need you to go into your Zoom app and connect your audio.
I think that's Ms. Giltz.
I'm sorry, what?
Jillian Wilson is the name that's appearing as Jillian Wilson is Alicia Giltz.
Oh,
I'm sorry, I don't know what you're talking about.
she's saying the girl that's appearing is the next case.
Oh, she's signed in under Jillian. Okay, you're saying, Ms. Bailey Quick, that is not Jill Allred.
That's correct. I know it's a little confusing.
Well, and your audio is going in and out, so your voice is, I'm not getting everything that you're saying, so that is making it a little more complicated. So, okay, let me put her in the waiting room. And are you ready to proceed with the Allred matter?
Actually, I have Mr. Triolo here, and the individual you just put in the waiting room was Alicia Giltz, appearing under the name Jillian Wilson. I think she's borrowing somebody's computer.
Okay, so you have Mr. Triolo?
Correct.
Oh, I'll bring her back then.
Sorry about that.
That's okay.
We moved closer to the computer. Is the audio better?
That helps, yes. Okay, so Miss Giltz, I need you to unmute. Okay, ma'am, can you just tell me your name for the record, please?
Alicia Giltz.
Okay. All right, we're on the record in Triolo versus Giltz. This is case number 2419736, and we have both parties present today, both by Zoom. And Ms. Bailey Quick, I do have a proposed consent judgment of divorce. Did you want to proceed with taking testimony from your client?
Yes, Your Honor. Thank you.
Okay, and Ms. Giltz, did you want to proceed with finalizing the divorce today as well?
Yes, Your Honor.
Okay, so Mr. Triolo and Ms. Giltz, I'm going to ask both of you to raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, Your Honor.
Thank you. You can lower your hands, and Ms. Bailey Quick, if you'd like to proceed with taking testimony from your client.
Thank you. Matt, would you please state your name and spell your last name?
Matthew Mario Triolo, last name is Triollo.
And at the time you filed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
And at the time you filed your complaint for divorce, had you been a resident of Otsego County for at least 10 days?
Yes.
Were you and Ms. Giltz legally married in South Boardman, Kalkaska County on October 22nd, 2022 by a person authorized to perform marriages?
Yes.
And are you aware whether or not Ms. Giltz is currently pregnant?
I am not.
Did you and Ms. Giltz have any minor children born of the marriage, either natural or adopted?
No.
At the time you filed your complaint for divorce, you had alleged that there had been a breakdown of the marital relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at that time?
Yes.
And is it true today?
Yes.
You've electronically signed the consent judgment of divorce and you've had sufficient time to review that judgment of divorce?
Yes.
And in essence, it provides that you keep all of the personal property and household goods that you have in your possession and automobiles and recreational vehicles in your possession. And that Ms. Giltz will keep all of the personal property and household goods in her possession.
Yes.
There is a vehicle that Ms. Giltz currently has in her possession that is financed and titled in your name. And the judgment allows her 60 days to get it financed in her name to remove your name. And in the meantime, she is to pay you the monthly payment via Venmo. You understand that?
Yes.
And if she is unable to do so within the next 60 days, then the vehicle is awarded to you for you to sell or do whatever in order to get rid of the liability.
Yes.
You understand the judgment also awards you the separate property that's your real property that was not a subject of the marital estate.
Yes.
Okay. Each of you will keep your own pension retirement accounts or IRAs, your own bank accounts, and your own debts and liabilities. You understand that?
Yes.
And in the judgment, it also provides that neither of you will receive any spousal support. And after entry of the judgment of divorce, neither of you can come back to the court and ask the court to modify that in any way. You understand?
Yes.
Are you asking the court to enter this judgment today?
Yes.
I don't have any further questions for my client, Your Honor.
All right, thank you. Ms. Giltz, I have a couple of questions for you. Are you currently pregnant?
No, sir. No, Your Honor.
Okay, and as Ms. Bailey Quick indicated, under this judgment, you would not be receiving any alimony or spousal support. You understand that you would not be able to come back later and ask the court for that?
I do understand that.
And I reviewed the proposed judgment. It does have your electronic signature. Did you in fact sign that judgment electronically?
Yes, Your Honor.
And did you read and understand all the terms in that judgment before you did that?
Yes, Your Honor.
Okay, and by signing that, is it your intention to abide by all the terms in that judgment?
Absolutely.
All right, thank you. Ms. Bailey Quick, did you have any questions for Ms. Giltz?
Do not.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties in this case. The court will sign that judgment. Ms. Giltz, do you have any questions at all?
I just need to know how to get the paperwork for the vehicle, as I have tried to reach out to Matthew Triolo for that said paperwork. As of right now, the tags are expired. I need to get insurance on it. Other than that, everything else is very understandable, and just need that paperwork.
Ms. Bailey Quick, can you address that issue?
Yeah, Alicia, I can give you a call later today. I have one more hearing or first thing tomorrow.
I'm sorry, you broke up a little bit.
I can give you a call after my next hearing, or so a little bit later today or first thing tomorrow if you want.
That would be perfect. Thank you.
Okay, very good. Thank you. Ms. Giltz, you're free to disconnect. And then Ms. Bailey Quick, do you have Ms. Allred at your office, or is she signing in separate? Okay,
Nope,
thank you.
All right. And we're
Mr. Dundon, what case are you calling in on?
It's Stockman Amur Credit versus Stockman, Your Honor.
Okay, I've got one other hearing and then I'll be calling that case. So I'm just going to put you back on hold for a minute.
Yes, sir. Thank you.
Okay, we're on the record now in Allred versus Allred, case number 2419730. The record should reflect that Ms. Allred is present by Zoom with her counsel, Ms. Bailey Quick. This matter was set for a hearing at 3:30. It's now 3:50, and Mr. Allred has not appeared or attempted to sign on. Did you want to proceed with taking proofs from your client in this case, Ms. Bailey Quick?
Yes, Your Honor, and we actually expected that he wasn't going to appear.
Okay. Ms. Allred, if you'd raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and Ms. Bailey Quick, please proceed when you're ready.
Thank you. Would you please state your name and spell your last name?
Jill Anderson Allreed, spelled A-L-R-E-A-D.
Thank you. And at the time you filed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes, I did.
And at that same time, had you been a resident of Otsego County for at least 10 days?
Yes.
Were you and Mr. Allreed legally married in Brighton, Livingston County, Michigan on August 4th, 1990 by a person authorized to perform marriages?
Yes, we were.
Are you currently pregnant?
No.
Do you have any minor children, either natural or adopted, of the marriage?
No.
At the time you filed your complaint for divorce, you had alleged that there had been a breakdown of the marital relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at that time?
Yes, that is correct.
And does that remain true today?
Yes, it does.
Are you asking the court to return to any former maiden name?
No.
You've had an opportunity to review the consent judgment of divorce that both you and your husband have electronically signed.
Yes.
And for the most part, you both negotiated this yourselves.
We did.
And by way of that, you and your husband still own one joint property together.
Correct.
That is listed for sale.
It is.
You've sold another joint property and have paid off some marital debt or all of the marital debt.
Yes.
And then you divided the net equity consistent with that identified in the judgment of divorce.
Yes, we did.
Contemporaneous with the filing of the complaint for divorce, you had also acquired separate property and purchased your own real property, correct?
Yes.
And that is awarded to you in the judgment of divorce. You've agreed that Mr. Allreed will retain 100% interest in all business and real estate associated with Mayfair Accessories, and that includes all liabilities with that business.
Yes.
You and Mr. Allreed have divided all of your personal property and household goods, and that is resolved. It is. Okay. Both of you will each retain the vehicles currently in your possession, and that's outlined in the judgment of divorce as well. And each of you will also retain your own pension and retirement accounts, which are specifically identified in the judgment of divorce. The judgment also specifically identifies specific bank accounts that each of you will retain and or sign off from. You agree with that division? Likewise, the judgment provides certain debts and liabilities to be assumed by each of you, or that was paid off from the sale of the real property. You agree with the division as outlined in the judgment of divorce?
I do.
There are certain debts that there are judgments against your husband, and those are specifically awarded to him as his separate debts, and you are not responsible for those at all in the judgment. Is that correct?
Yes.
Okay. In the judgment, it also provides that neither of you will receive any spousal support, and after entry of the judgment, spousal support is forever barred, and you cannot come back to court and ask for any modification or change to that provision. You understand that?
Yes.
Are you asking the court to enter the judgment of divorce?
Yes, I am.
I have nothing further, Your Honor.
All right, thank you. The court has reviewed the proposed consent judgment. I do note that although Mr. Allreed is not present today for the hearing, that he did sign that judgment along with Ms. Allreed. The court finds that it contains all the provisions required by statute. The court is satisfied based on the testimony of the plaintiff that the statutory grounds for divorce have been met. The court will grant the divorce, and I've signed that judgment as presented. Anything else that we need to address for this file today, Ms. Bailey?
No, Your Honor.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
Your Honor, my car is not moving, just, not that you're too concerned, but I'm just at my son's football practice, but I didn't want you to think I was flouting the rules and driving.
No, I can see the trees behind you are stationary, so
Yes, sir.
unless you got some really, really good CGI going there, I accept that you're not driving.
It's actually it's a good idea.
Okay, and we have, okay, we've got both counsel connected, so let's go on the record in Amur Equipment versus Stuckman. This is case number 2419661. If I could just have counsel both put your appearances on, starting with plaintiff, please.
Yes, good afternoon, Your Honor. Craig Mears on behalf of Amur Equipment Finance Incorporated.
Good afternoon, Your Honor. Mark Dundon appearing on behalf of defendant Jacob Stuckman, who's also a cross plaintiff in this matter as well.
Okay, we're on the record here today for motion to enter a default judgment. I did have a chance to review the motion and supporting documents. Mr. Mirzwa, is there anything that you wanted to state for the record today?
Not if it's not necessary, Your Honor. This is a breach of a commercial lease agreement. And obviously suit was brought against the company and Mr. Stuckman. Jacob Stuckman, who Mark Dundon is appearing for today, is a guarantor. And Mr. Stuckman and the company, Frank Stuckman that is, have not filed an answer as required under the Michigan court rules, and a more respectfully request the entry of a default judgment in an amount of $133,595.92 with interest accruing at 18%, which is the default rate under the terms of the contract or lease agreement from November 15th, 2022 until the entry of judgment. And all of that is spelled out in the affidavit that Amur filed from Carla Barron in support of this motion for default judgment. So if there's no objection by anyone here today, I would respectfully request that the judgment be entered in accordance with the motion. And as I did submit a proposed default judgment against Mr. Stuckman and the company. And again, this is Frank and not Jacob. We'll be dealing with Jacob by a motion for summary disposition in the next few weeks, I think. So with that, I would respectfully request that the motion be granted.
Thank you. Mr. Dundon?
I'm not opposed to the entry of the motion. We're obviously, I'm not going to weigh in on the numbers or what they are, but if he didn't answer, he didn't answer. So we're also going to be, just so the court's aware, we're likely going to be filing our own based on our cross complaint. I believe I'm coming up on the 28 days fairly shortly.
Okay, very good. After reviewing the file as well as the motion and brief filed by Mr. Mirzwa, the court finds that it would be appropriate at this time to enter default judgment against Stuckman Tree Service, Inc. and Frank Stuckman only. I do have a copy, as Mr. Mirzwa indicated, for signature, so I'm signing that default judgment with today's date. Mr. Mirzwa, anything else I can address for your side today?
No, Your Honor, that is all. Thank you very much.
Mr. Dundon, anything further for the record?
No, thank you, Your Honor.
Okay, thank you. Both counsel are free to disconnect at this time.
Thank you very much, Judge. Have a great day. See you, Mark.
Yep, see you, Greg.
Looks like we have both counsel connected, so we'll go on the record in Martel versus Simpkins. This is case number 2218919. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Dave Glenn, Kuhn Rogers, on behalf of the plaintiffs, Martels.
Thank you, Your Honor. Jason Thompson on behalf of the Simpkins defendants.
Okay, Mr. Glenn, this is your motion requesting sanctions for failure of the defendants to comply with prior order of the court compelling certain discovery. I did have a chance to review your motion as well as the attachments. Is there anything that you wanted to state by way of oral argument today?
Not much, Your Honor. I think it's pretty self-explanatory the way it's laid out. Unless I'm missing something, the attached discovery from Amazon doesn't appear to match any of the existing knowledge that we have of those cameras. I mean, it's pretty obvious that especially that one, for lack of a better term, globe camera that faces the Martel property doesn't look like it's even close to the cameras that are referenced in the Amazon advertisement. So it's pretty obvious that those aren't the cameras that are installed on the property, and we have no actual information other than just looking at them. And I've done my best to try and Google cameras that look similar to see what their capabilities are, but without actually knowing the model numbers and the cameras themselves, we're unable to know what their capabilities are. And like I said in the motion, this is now our third motion to compel. Wasn't exactly even sure what to call it, but it's a motion brought under court rule MCR 2.313B, which I think addresses situations where you've had repeated failures to provide the discovery that's requested. And I think we have that here. I'll leave it to the court's discretion on how it wants to handle it and what relief, if any, it wants to order. But we're kind of left with our hands tied. We have a trial upcoming in October, I think even early October on the 3rd. And we don't even know what we're dealing with as far as the cameras. So I probably should discuss that date as well at this hearing, but I'll give it over to Mr. Thompson here. Thank you.
Thank you. Mr. Thompson, your response?
Thank you, Your Honor. Our position is we complied fully with the court order. We provided all the model make information from the Amazon webpage for all the cameras on the property that Mr. Simpkins uses. I got a question from counsel that there's a larger camera, I guess. Sent back a supplement that said that it doesn't work essentially. I'm probably getting out of my depth technologically, but it doesn't. He's not able to utilize it for anything. It's outdated. So it just sits there for kind of deterrence purposes, but it's not used. So those are our responses, Your Honor. We believe we fully complied and we don't have anything we need to add to our responses. Thank you.
All right, thank you. Mr. Glenn, it's your motion. Anything that you wanted to say in response?
Yeah, I just find it hard to believe that thing doesn't operate. I mean, in discovery previously, they provided photographs and video frames in the previous case from that camera. It's a pretty sophisticated looking camera to be up there as a decoy. So I don't know. I would find it hard to believe that it's up there without power or whatever. And if it is, I mean, they were pretty reluctant to bring it down upon request. So yeah. I find that hard to believe.
All right. Again, I had a chance to review the motion and the supporting documents. Looking at the responses to the interrogatories, the court finds that they are not sufficient, with the exception of sub C. I find those answers to be responsive. However, the court finds that just putting a Amazon ad is not responsive to the interrogatories, particularly with at least one regard to one camera, which the supplemental response, I believe, indicated was installed 10 years ago, so clearly the Amazon ad can't refer to that. And so based on that, I don't know that it's accurate as to any, some or any or all of the other cameras. So the court finds that the answers to their interrogatories are not sufficient and not responsive under the court rules. So in response to that, the court has a number of different options. Number one, the court is going to order that the defendants provide the make and model of each specific camera, that the defendants provide either a website or a link to owner's manuals that are specific to those makes and models, or to just simply answer the questions with regard to the capabilities of each of those cameras, one or the other, so that the plaintiffs have an ability to understand what kind of cameras they are, what model they are, and what their capabilities are. And then the plaintiffs can take that information and do further research, I guess, if they want. In terms of a sanction, the court has multiple different types of sanctions at its disposal for violations of discovery orders. In this case, I don't find that drastic sanctions of default or dismissal are appropriate given the circumstances. However, the court finds that this is a motion that didn't need to happen. So the court is going to award attorney fees and costs related to the filing and arguing of this motion. Mr. Glenn, I'm going to ask that within 14 days you provide the court with an accounting. The court still is required to examine attorney fees and costs for reasonableness. So once you submit those, Mr. Glenn, I will conduct that analysis and issue an order. And then the court is also going to order that the responses, as I've indicated, be provided to plaintiffs within 14 days. And so, Mr. Glenn, if you can prepare an order reflecting that the court's granting your motion for the reasons stated, and the other specifics that I've indicated. Have I been sufficiently clear, Mr. Glenn, for you to be able to craft an order?
I believe so, Your Honor. Yep.
Okay.
Your Honor, may I interject here real quick, please?
It's up to you. You can talk to your attorney and see.
No,
if
I'd rather
options.
not. I'd rather not. So just to clarify what he provided to the court, the PTZ camera on the peak of the house is 10 years old. It was not purchased from Amazon. It was purchased from a company who is no longer in business. The software is no longer supported. So therefore, that camera is no longer functional. I put that in my note to my attorney, Jason Thompson. It clearly says the software is outdated. That camera does not function any longer. The Amazon description, because they wanted all the details of the cameras, the Bluetooth cameras that we have on the property are the 4 or 5 are the Wise camera system. Those are the only functional cameras on that property. So we provided what the court and the council had asked us to provide to them. We did in detail. The ad from the Amazon gave you every detail of those cameras, more so than I possibly could tell you what those cameras functionalities are. So once again, back to the rooftop PTZ camera, that camera is not functional. That camera will be coming down once they start construction on the property. I don't have the ability or nor do I like heights to climb up there and remove that camera. And I believe in our answers, we did say that that camera software is no longer supported. That camera is not functional. Those are the camera. I don't even know what the brand of that camera even is. So I understand maybe where you're coming from, but we did answer and we did respond. The Amazon, you're right, Amazon probably wasn't delivering cameras 10 years ago. Who knows? I don't know, but it didn't come from Amazon. I don't know who it came from. I have a phone number. That phone number is no longer available to get a hold of anybody, so I assume that company is out of business. But once again, the software is not supported, so those cameras are not functioning. The only cameras, once again, functioning are the ones that we purchased from Amazon, which the Martells know where all those are at on the property, because they walk around, they see where all the cameras are at. So we've exposed all the cameras, and they also want to know what the cameras would take pictures of. We also set examples of what those pictures are of, what those cameras took pictures of. So I feel that we did comply with what the court was asking for. I don't know how we did not comply. I mean, if we stated in our answer that the camera is not supported with software any longer. Now, council does have a right, they can subpoena us and they can come to the house, they can check those cameras and verify that if they want to. They have 14 days to do so. And if they want to do that, I'm more than welcome to open the doors up and they can come in and verify that that camera system is no longer functioning. It's you know, I think that's a fair statement. So I just want to put that out there to the court that we did provide what the court asked us to provide. So I just leave it at that. So the cameras we have that are functioning are the WISE cameras. The PTZ on the peak is not a functioning camera. Has it been functioning maybe about a year now? I know council says, well, we have pictures. We do. Those pictures are from many, many years ago over the property dispute. Those are old pictures. You and I both know that. The court knows that. So that camera hasn't functioned. I'm thinking maybe a year, a little more than a year. So I don't know what the relevance of what more information are they asking for? I'm confused because we gave council what they were seeking. So I don't just leave it at that, and hopefully the court will reconsider its determination on this. Thank you.
Okay, thank you. My ruling is what it is, and so Mr. Glenn, I'll just ask that you submit the order as I've indicated today. In terms of the trial dates in October, unless one party or another files a motion, I'm going to consider that trial date to be on. And so the court's at this point not going to consider adjourning that or moving that, absent one side or the other filing a motion, providing good cause and justification for doing so. That's all I have for the record today. All parties are free to disconnect at this time.
Thank you, Your Honor.
That also